Well, hello and welcome to Chicago Newsroom here on CAN TV. I'm Ken Davis. As you probably know, here on Chicago Newsroom, we talk about journalism. We talk about the issues that are sort of in the background that help journalism survive. We've talked about the history of journalism. We've talked about the future of journalism. But today we're going to talk about sort of the bones and the structure of journalism, the Freedom of Information Act. If you don't have access to information, how can you be a journalist, right? So what is the Freedom of Information Act? How does it affect the news? How does it affect what we read and what we watch? We've got two experts with us today, and I think we're going to have a very interesting and lively discussion because I'll bet you didn't know the status of the Freedom of Information Act in Illinois. It's really kind of under assault right now, and we're going to find out about how that is. Joining me first is Tracy Siska. He's the Executive Director of the Chicago Justice Project. The core mission of CJP is to increase public access to justice-related information. And among its programs is the use of the Freedom of Information Act as a central way to generate data for public access and government accountability. I'm also very pleased to be joined by Phil Kander today. Phil Kander is a longtime columnist for the Southtown Star. He's nationally known, really, for his advocacy of Freedom of Information Act and Open Meetings Act compliances. And he played a key role, and this is the important part, in the creation of a public access counselor in the Illinois Attorney General's office. Kind of a behind-the-scenes thing, but something that's very interesting. We're going to talk about that. And Phil, first of all, of course, congratulations for your Chicago Headline Club Lifetime Achievement Award, which is just a few days old now. It was a real pleasure to see you there for that. You've made a number of extraordinary contributions to the idea, to the concept of freedom of information, and you know, I didn't even realize this until the ceremony the other night, but you are sort of like the last man standing. You are the last of the 5-day-a-week columnists in the Chicago region, right?
Right.
How'd that happen?
I don't know. I always figured I might not be the best columnist, but it could always be the hardest working.
The hardest working man in columndom.
Right.
Well, I mean, you actually have I mean, we could just sit here and just do a half-hour sort of discussion about you and your history. The whole thing with Southtown, you're really kind of one of the sort of founding flames of the Southtown and journalism in the Southland.
Thank you much.
And you did play a very important part in conceptualizing a lot of what we now take for granted in freedom of information in Chicago. I am affiliated with the Chicago Headline Club. I'm on the board of that, and we were very pleased a few months ago, back in, I don't know, October or November, to host Lisa Madigan for an event that you actually hosted. And things looked really good in that time. Things had turned around. We had a new governor. We had a sort of a new attitude in the state, and we had an attorney general who appeared to be absolutely doggedly devoted to getting information out to the news media when it was needed. And it's not so much anymore. I mean, that's kind of the impression I'm getting. Fill us in on this.
Well, I don't want to say not so much anymore, because there's still some changes that are very significant, I think, in the history of Illinois. And the key to that is the Public Access Counselor. Because the Freedom of Information Act, no matter how good it is, isn't effective if you can't use it as a citizen or as a member of the news media. And even the news media often doesn't want to go to court these days because they have financial problems to try to enforce the law. And the people you're trying to enforce this law against are normally big governments, and these people aren't pulling the money for their attorneys out of their own pocket. They're using taxpayer funds.
Exactly.
And they're often very happy to go to court if they don't want to release information that the public should have. And so the key to this was the Public Access Counselor in the Illinois Attorney General's office is truly supposed to be a people's attorney. If you file a request for information under the Freedom of Information Act and an organization refuses it, under the new law, they now have to send that refusal to the Attorney General's office, which will review that and decide whether or not is an accurate refusal. So you don't have to hire an attorney to do that for you anymore if you're a citizen or a member of the news media. The Attorney General automatically does that in every case of refusal. They will then decide, they will tell these people either no, this refusal is not allowed under the law, or it is, and if these people continue to refuse to release the information, the public access counselor then has the authority to issue an opinion which has some legal weight saying that this is wrong. If these people then decide to go to court, that opinion will weigh heavily with the judge, and the public access counselor can go to court on behalf of the public or the media and say this information must be released. So that's a powerful element that never existed before in this state.
I want to hear a lot more about that, but I think at the moment we have to sort of begin with the basics, because people who are watching this may be sort of vaguely familiar with this idea of FOIA, you know, freedom of information. It's been around for a long time. But how it actually affects individuals and how the news that they consume and that kind of thing, that's what I really want to focus on today, and see whether or not that's being eroded or whether we need to strengthen it or whatever. And Tracy, you're probably the guy to bring in on this now. Tell us, first of all, just tell us a little bit about the Chicago Justice Project. How did you get involved in all of this FOIA stuff?
Well, I founded the Chicago Justice Project as a vehicle to inform communities about what's going on in their community in reference to the criminal justice system, and then how, when that arrest happens or when the assault happens and there's a complaint, how that complaint or arrest travels through the rest of the system, and to inform communities how it's not just the police that affect what goes on in their communities. There's an interrelationship between all of the agencies. So to do that, when we created the Chicago Justice Project, we knew that the FOIA was not very strong in Illinois, and we knew that we were going to have to probably litigate a lot of times to get access. And our goal was to litigate for continual access, not just one-off access, which is another, hopefully it will be a benefit of the PAC, is that if the Public Access Council continues to litigate, eventually it becomes politically a political problem for municipalities to hold the information. So maybe there becomes regular access, because as good as one-off access is, regular access is really what people need.
Like a data stream. I mean,
like a data stream.
Particularly, I'm sure, police, although there are a lot of other agencies too. But I mean, this is part of where this becomes complicated, isn't it? Because you really need to be able to not only just get clumps of data, but to be able to sort through it, to be able to kind of figure out, you know, what is behind. If you see an arrest pattern, for example, of some kind of thing, of arrests happening in schools or of a certain age or something, you want to be able to get hold of that database and do your own sort on that database, I presume, right?
Correct, and I think that is one of the other real benefits of the new law, is that it mandates that if public agencies have data in a digital format, which is in databases, they must release it in that digital format if it's requested. And that's really the most important aspect for not only citizens but journalists. It's not good journalism, it's not good public policy to make policy or flashy stories about one individual case. That's a misnomer that may have happened for a variety of reasons. What you need to look at is the whole span. You need to look at a year's worth of activity or 5 or 10 years worth of activity to really know how the agency or the system is operating and to know whether it's operating poorly or if it's operating well. Because one incident may just be a single agent of that agency just misbehaved. And if that's it, you deal with it.
Now, I don't want to get too far off on a tangent here, but I think that's a very interesting, it is an interesting little side note to this, because very often when journalists go to a big agency like the Chicago Police Department or the Chicago Public Schools, and they say, we want to know, we're looking at some trend or something, we do need like raw data. And the question is always whether that's actually being kept, because very often what you get is, oh no, we don't do that. We don't look at the number of arrests that have been made in the CHA or something like that. So how do you first of all even know if this data exists, and if it does, how do you get it if they have reasons not to give it to you?
Well, it's another benefit of the Public Access Counselor's Office being there, is that quite often the agencies would say no, and they've said no to me over the last year. No, 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 we're not going to give you our database. No, 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 we're not even going to give you the fields we capture. So that right there, it limits any ability to have any knowledge about how you might use information because you don't know what they keep. Where the PAC is going to easily, in my opinion, would easily look at that and say, no, there's nothing wrong with telling them the data points you collect. You're not violating anyone's privacy. Tell them what you collect. They can then file an informed request knowing what they're going to research, and then we can have a discussion about whether that stuff should be released.
Phil, you must run into this all the time. I mean, you go after an agency wanting to know sort of the big picture about what they're doing, and they'll just say, no, we just don't even have that. We don't collect that data.
You do get that. In theory, they're supposed to be able to produce for you a list of the documents that they have on file. You know, the problem is most reporters don't have the time to often go through all that information. That's just a fact. There are very few investigative reporters these days that can spend the time to sort through a big collection of information like that.
Well, that, of course, is, as so often happens on this show, one sentence leads us off into another half-hour show, and that's one right there. The fact that there are so few news organizations left that have the ability to spend a week or a month pouring through this data and putting it up on a rack of computers and having 5 interns look through it. I mean, I get the impression that almost just doesn't happen anymore in our business, and that's a real shame. But I guess we'll have to leave that for another show. The thing we're interested in today is that when we first find ourselves in this kind of this moment where we have the public advocate and we have a kind of an opening up of the FOIA laws, as one might suggest, very easily the first thing that starts happening is that individual interest groups start saying, this is great, except that I don't want you to have my piece of data. And one of the first places that happened, and it was very controversial, was teachers. Tell us about that. What happened there?
Well, the new law allows for personnel evaluations to be public knowledge. And the reason the new law really emphasizes these kinds of things is that under the old law, many government agencies discovered that by filing things in personnel files, they could claim a privacy privilege for that individual, and you couldn't get information. And it worked as simply as this. Somebody had a new contract, a school superintendent or police chief, and they put it in the personnel file. You say, I want to know what the terms of the contract are. Publics ought to be entitled to know what they're paying this guy, if they're giving him a car, if they bought him a house, if he's getting 10 weeks of vacation a year, or whatever perks he has. And they would say, no, you're not entitled to that information as part of his personnel file. So they would dump everything in the personnel file, and it became a dumping ground. You had to go to court to get it, and there were a number of court rulings, some of which said, no, you can't do this stuff. But that became the problem. So now the new law gets into effect, and it says, okay, you know, personnel evaluations are part of the public information. The public employees didn't want that, and the first group was the school teachers who went down to the legislature and asked for a special exemption in the law that would allow them to basically subvert the FOIA law as far as they were concerned. And they tied it to a piece of legislation that would eventually, theoretically, have benefited the state by giving them billions of dollars in federal aid for the schools. So the legislators don't want to subvert that, but the unions, meanwhile, teachers' unions have enough power to sway enough legislators to kill the bill. So they say, we'll give you that exemption. Your personnel files are no longer going to be in this. Well, then you get superintendents and principals in schools. They jump on board.
Wait a minute. What about us?
Me too.
Yeah.
Well, then you get every other public employee union in the state, police, you know, fire, the municipal employees saying, we want that. We want that.
Well, let's look at this for a second. what is the, just to sort of play the other side here for a moment, because we did attempt to get a number of different union representatives who have been advocating for this, and they were too busy. I guess they're down in Springfield lobbying or something, too busy to come on the show. So it falls to me to ask the question, really, do we need to have a performance evaluation of Johnny's teacher be a public document? I mean, isn't that really the essence of like a personnel relationship?
We absolutely need access.
Why?
And this is the reason. Because you're not necessarily looking. People automatically assume the worst case scenario when anything is going public. It's a knee-jerk reactionary issue that always happens. What we need to know is whether or not that teacher, not just on a 1 year, but has had 15 years of bad evaluations, and because she's friends with the principal, he doesn't fire her. And who he does fire is someone who's had 10 years of good program personnel evaluations, but he doesn't like. That's what we need that for. It protects the employees as much as it would ever hurt them. The average citizen doesn't go look to get an evaluation from their teacher to make fun of them. People are looking to make sure that the institutions are working properly.
But the vast majority of FOIA requests, as I understand it, don't come from journalists. They come from interest groups and private citizens and other agencies, right? FOIA covers much, much more than journalists.
Yeah, and that's what people don't understand, and that's one of the keys to getting the new law passed is, and I did write down some numbers here. I hope
oh, good, we have numbers.
From a piece of paper. Last year, the Attorney General's office got 1,298 calls regarding FOIA cases. 962 of those came from average citizens. 962
wow.
of about 1,300. 276 came from public officials. People don't realize often if a public official gets elected as kind of a maverick reformer, they get elected, they often get frozen out of information.
They don't get the information either.
And they end up being the ones, and I've discovered this more and more in recent years, they're often the ones calling me as a reporter saying, how do I get this information? They're not letting me look at the budget. And I'm going, God, they can't do that. And I said, I know, but they're not.
Yeah.
Only 60 calls from the news media of the 1,298.
60 out of almost 1,300.
Right. So they're by far the lowest.
Yeah.
And often that's because we probably know the law a little better, so we're not making as many calls to them. We have access to other kinds of attorneys, our own attorneys, municipal attorneys who we have as sources who we rely on. So we probably don't make as many calls except when we really think a case is blatant.
But if I sort of turn the binoculars around and look at it from the other end, and I imagine myself being a teacher in a tough situation in a difficult school with a kind of a rough relationship with my principal, but I think I'm doing a really good job.
Right.
I could see how I don't want to just have my performance evaluation available online for anybody to just look at.
That's why I wish those people were here today, because I'd love to debate them on this issue. Because, I can sympathize with that and understand it. Now you're that same teacher, and your kids go into a party on the north side of Chicago, and the kids are out on the balcony partying, and the balcony collapses. And you go to court and you find out the building inspector who inspected that balcony had 24 complaints against him for being negligent on the job, but he was a relative, perhaps, of his boss or somebody else in city government. Now, wouldn't it have been nice to have known that before that balcony collapsed, so that something could have been written about it, he could have been exposed before your kid died? Now, you're the teacher. I think I know what you're going to tell me, yeah. But that's the case all the time. I want my protections, but we all need this information to protect us as a group, as a whole.
I'm not doing a very good job of being the advocate for the other side here. I admit it, because I guess I have my own biases. But it does seem to me that maybe there's a sort of a continuum here. A building inspector is somebody who, or a police officer is somebody who has a direct connection to the public and deals in life and death situations. A teacher, not quite that, not the same thing.
I would argue,
take that?
yeah,
I could jump all
yeah,
over it, but
I
go
would
ahead.
argue significantly against that. I would say one of the most important people in the children's lives are teachers, are the people they spend 8 hours a day with 5 days a week, outside of their parents, that are most important. It isn't the police, it isn't the fireman, it isn't the paramedic, it's the teacher. And I think that there's this assumption that all teachers are bad. I have teacher friends that were like, ooh, yeah, I understand where teachers who don't do that good wouldn't want that out there. But the reality is, you know, citizens need to realize that the first couple years, most teachers, when they're starting out, get bad evaluations. Not because they're bad, because they're learning. Like anyone does on a new job, the evaluations aren't great, and they tend to go up. And if they're not going up, something needs to be done. You can't have just protect this job.
I have to point out there are a lot of safeguards already built into this law. It says that personal information does not have to be revealed about people. So if there's a social security number, if there's a medical condition, you can release the documents and black out that information. If you want to refuse the information under the way the law existed, you could refuse it. It goes to the Attorney General's office. The Attorney General's office looks at your reason for refusal. If you're saying, well, listen, you know, this person, there's this reason that's very valid that we don't want to release this information, the Attorney General could say, great, we keep this information, this part secret, we release the rest. Even if the Attorney General says you have to release some information and you don't want to, you could say, we're not releasing it anyway, we're going to go to court and we'll fight this out in court. All these backstops, all these protections, but these people don't want to even have those rules. They just want a blatant document saying we don't have to release anything.
So, looking over the last couple of months, it appears to be that there's been a kind of a buffet of pecking away a little bit of this and a little bit of that. What else has been changed in the Illinois law, and what do we have to look forward to?
Well, as we speak, all the public employees in the state are looking for that same exemption as the teachers get now. They want
And what is the prospects for that?
The prospects are very good. I'm told it's down in the legislature as we speak. It passed the House already. It's in the Senate, and I'm told it's very good that it'll pass.
And if it passes, it will do what?
It will exempt all the personnel evaluations of all public employees.
What is a public employee?
Anybody paid by the government, municipal employees, library employees, fire department employees, police employees, anybody who works for a government agency. Their personnel evaluations will remain private. Those building inspectors, all those people are covered. But this is just the beginning. People will peck away at this. This is what happened to the old law. People will peck away at this. If they can't get the legislature to put a hole in it, they will go to court and try to get the courts to put new loopholes in it.
Tracy, it's more than just personnel, though, right? It's more than just evaluations and
yeah,
so forth.
there's 8 other bills right now that are active. They tried to have one that was all for police performance evaluations. That bill died, but is covered by the public employees bill, so it's kind of meaningless. They also tried a bill where we're going to remove the mandate that public bodies release information in a digital format, even if they maintain it that way, which was in my opinion, was a clear attempt to really try to retrograde the act as much as possible. One of the favorite exclusions that the municipal bodies used was your request is overly burdensome. So if you were requesting information that was over a month or a year's time, say overly burdensome, and it was incredibly hard to fight that. Well, the digital mandate says, well, you can punch a few keys, burn a disk, I'll give you a thumb drive, put it on there, it's done in 15 minutes.
Or it could even just be a file transfer. I mean, you could literally just
email the file,
push the send button, and you've got
Correct.
it, right?
So, listen, I'd like to say this. I'm considered a big advocate of and I was integral to helping get the Freedom of Information Act put into law. We shouldn't even need a Freedom of Information Act. This information in this age, anything that's kept on a computer, that there's a public access file, it should be available to everybody. You shouldn't have to request it. It's information generated with your tax money. It says how your tax money is spent. And so much of this information doesn't violate anybody's privacy, and people should have access to it so they know how their government is working. It would prevent a lot of the corruption that occurs. So you shouldn't even need a Freedom of Information
Well,
Act.
I know from experience, and I'm sure you guys have had similar experiences, that very often government agencies will avoid even creating a document for the very reason that they don't want to have anything in the file. And that is just a very skillful way of circumventing the law by just sort of like not getting into it in the first place.
Sure.
So you have sort of, again, sort of the letter and spirit of the law, and when the spirit is that we don't want you to know what we're doing.
Government agencies get very creative. We had a school district that went millions of dollars over budget in expanding one of its high schools. They then hired a consultant to come in and evaluate why they had done what had happened. The consultant's report, they didn't make that available to us for a long time, claiming it was pending litigation, which is an exemption. Eventually what they said was they didn't have it in their possession, they had given it to their attorney, therefore it was attorney-client privilege and not a public document. That's how creative they get. They have a consultant's report they paid for with taxpayer money to study why they overspent taxpayer money, and instead of making it a public document so everybody could see what went wrong and look at it, they let their attorney put it in a file and say now it's attorney-client privilege.
You know, I got to say as we conclude here that I just have this kind of nervous feeling. We've been sitting here talking for almost a half an hour, and that people who are watching this, a lot of them might be thinking, this is so inside baseball. Yeah. Look at these guys just sitting there talking about yak about who cares about freedom of yeah. I mean, I need you to put this in some kind of emotional, conclusive perspective for me. Why should anybody watching this just give a damn about this?
If you look at policing in Chicago, between 2001 and 2005, the city of Chicago paid out $100 million in civil suit settlements and judgments for police officers' misuse. We have no access to their performance evaluations or citizens' complaints against them. Last year, it went up to $72 million. That was 1 year of taxpayer money. Once again, we still don't have access to their performance evaluations and the citizens' complaints, and now we're going to make sure with this new law that we don't. I mean, at what point does that payout become too big? And the city's broke, we're laying off teachers, we're furloughing people, and we're paying all this money out, and the public has no access to who that is and what's happening to them, whether they're losing their job. I'm just wondering at what point does that amount of money get too big for Chicago taxpayers to think we have to do something about it?
So, Mr. Lifetime Achievement, I mean, what's your perspective as you're sitting here right now? Are we losing or are we gaining in this?
No, we've gained a lot, but you have to fight for it. I mean, this is a constant battle between the bureaucracy and the public. And the bureaucracy wants to do what's best for them, and that's hide. If you keep information private and the public can't get it, they're better off. And it's pretty simple. This is your government. It's your tax money. You have a right to know how it's spent. And anytime the government tells you, no, you're not entitled to information, you ought to be saying, why the heck not?
And that's something that's really hard to keep in perspective. That, you know, I mean, I know how goofy this sounds, but, you know, these folks do work for us as citizens. They are our employees, after all. We've hired them to do this work. And, yeah. Well, guys, I've really enjoyed this. It's been an interesting conversation, and it will be going on, and we should keep an eye on that Illinois legislature because people say they can't get anything done, but under certain circumstances they can get a lot done, right?
Right.
Well, thanks very much for watching us here today. You've been watching Chicago Newsroom. It's a community service of CAN TV. And I want to thank Tracy Siska from the Chicago Justice Project and Phil Kander from the Southtown Star for being here today. You can find us here on cable, of course, anytime, but you can see this and other programs online at cantv.blip.tv. Check us out or subscribe using iTunes. I'm Ken Davis, and thanks very much for watching us here on Chicago Newsroom.